Hello, I'd like to talk to you today about a very interesting First-Tier Tribunal capital gains tax case called Moore and HMRC 2016, which was heard very recently. And the important point that it makes is it illustrates how overlooking small but important details can sometimes have very costly consequences for clients, particularly when you're looking at the useful entrepreneurs relief and the 10% rate that follows that in the context of capital gains tax. Now, the facts of this case can be quite simply told. Taxpayer involved was a gentleman called Mr. Moore, and he was the founding shareholder director of a company called Alpha Micro Components Limited. It had been set up more than 20 years ago in, I think, 1995, and Mr. Moore had a 30% shareholding. He was employed as a sales and marketing director, and unfortunately what subsequently happened was during the course of 2008, a dispute arose between Mr. Moore and his fellow directors as to the future direction of Alpha's business. Mr. Moore was unsuccessful in arguing his corner, so the end result was that he agreed to hand in his cards and leave the company behind. So this was concluded by means of what's usually referred to as a compromise agreement, under which effectively his employment ended. The company agreed to buy back his shares. Papers were filed at Companies House to this effect, saying that he had resigned his directorship on the 28th of February 2009. But, and here's the rub, unfortunately the company didn't resolve to repurchase Mr. Moore's shares for another 3 months. So not until the 29th of May 2009. As you'll all be aware, there is an important rule in the Capital Gains Tax Entrepreneurs Relief Code, section 169I, subsection 6B, TCGA 1992, which says that any person disposing of shares has to have been, in addition to having at least a 5% shareholding, which clearly Mr. Moore did have, having 30%, he also had to be an officer or employee of the company throughout a period of 1 year ending with the disposal of his shares. And of course, HMRC contended that because the disposal of his shares didn't take place until the end of May 2009, some 3 months after he'd resigned his directorship, that he clearly didn't satisfy that. He'd been a director for the first 9 months of that final 12-month period, but he hadn't been a director or employee for the last 3 months. And it's got to be throughout the final 12 months. So effectively, his claim for entrepreneurs relief was turned down. He wasn't entitled to make it. When the taxpayer and his advisors and HMRC couldn't settle this argument, it ended up in the First-Tier Tribunal earlier on this year. The argument that Mr. Moore advanced before the First-Tier Tribunal was that actually his disposal took effect from the date of that earlier compromise agreement, which was dated late February 2009, at which date, of course, he was still a director, and therefore, if that was deemed to be the date of the disposal, he would have satisfied the last 12-month rule. Unfortunately for Mr. Moore, that argument wasn't accepted by the judge in the First-Tier Tribunal, and the reason it wasn't accepted was quite simple. There is a measure in the Companies Act 2006, it's in section 694 of the Companies Act, which says that before a company can buy back its own shares, it requires the passing of a special resolution. So in other words, as a company, you can't have an own share purchase unless you have already passed the requisite special resolution. Because the passing of the special resolution didn't take place until the 29th of May 2009, it meant that Alpha, as a matter of law, was incapable of entering into a contract for the repurchase of Mr. Moore's shares before that date, and as a result, therefore, there was no doubt but that the disposal actually took effect in the end of May 2009. Now, the irony, of course, was that Mr. Moore, despite resigning his directorship some 3 months earlier, had actually continued to work for Alpha through his own personal service company, a company called JM Technology Solutions Limited that he'd formed, I believe, specifically for this purpose. But it's well known that, of course, if you're supplying your services as a consultant, that is not the same thing as being a director or an employee. It's a very important aspect of the Entrepreneurs Relief Code. Where it requires you to be an officer or an employee, being a consultant, which is effectively what Mr. Moore was, is not good enough. And in those circumstances, what that meant was that the court concluded that the revenue stance was the correct one. He, strictly speaking, wasn't entitled to entrepreneurs' relief, and therefore, of course, had to pay nearly double the capital gains tax rate. In 2009-2010, when he made his disposal, the normal rate of capital gains tax was 18% compared with the entrepreneurs' relief rate of 10%, or effective 10% in those circumstances. So effectively, unfortunately, Mr. Moore's capital gains tax bill was virtually double what it would have been had they taken a little bit more care and thought. Just a couple of points that we might put. Why didn't the company simply put Mr. Moore on gardening leave between their decision to get rid of him in February 2009 and May 2009, when they actually resolved to buy back his shares and eliminate his shareholding in those circumstances? If he had been put on gardening leave, to use the commonly used phrase in those circumstances, that would have been perfectly okay. He would still have counted as an officer or employee. The other surprise that I have is, why did it take Alpha so long, 3 months, before they passed a special resolution? Giving notice of your intention to pass a special resolution doesn't require much time by way of notice, and it seems a little surprising that it actually took the company as long as 3 months before they actually got round to passing the special resolution. If they had passed that special resolution at the time when the compromise agreement was drawn up, in other words, back in February 2009, that would presumably have sufficed. And the parties, particularly Mr. Moore, would have been happy all round. The important lesson, I think, of this case is that it really serves to emphasise and underline the importance of clients seeking proper professional advice before undertaking transactions of this nature. Although the case report doesn't make it absolutely clear, it would appear that probably what happened, Alpha, the company, Mr. Moore and his fellow directors, just went ahead with their argument and their decision, possibly consulting lawyers, but not involving their tax advisors until it was too late. And that seems to be a great pity, because it wouldn't have been hugely difficult to have ensured that Mr. Moore ended up with his proper 10% rate. After all, he had had his shares in Alpha for the best part of 14 years, and it was a 30% holding, so there was no doubt but that he should have got entrepreneurs' relief when he sold his shares back to the company. But unfortunately, as I say, they got their timing wrong, and that was the critical problem area in this case. Thank you for listening to this talk. My name is Robert Jamieson.